Good morning and welcome to the Interest Group's webinar today. My name is John Paul Ruiz, the Director of Professional Development here at the Interest Group. The title of the webinar today is New Year's Resolution, Get Your Old 401k in Shape. Now keep in mind when we say old 401k, we're talking about if you have ever worked for an employer that has a 401k plan, a 403b plan, or maybe even a governmental 457b plan, and you have reached one of those what we call triggers, which we'll discuss in this particular seminar. You have an opportunity to move those assets someplace else to avail of other types of investments. And that's the focus of today's webinar, is what to do with your old 401k plan, governmental 457b plan, or old 403b plan if you ever worked for local municipality, school district, or a nonprofit organization. Now, before we get started with the seminar, this seminar, of course, will last approximately 45 minutes long, with the first part of the seminar devoted to the presentation of the material, and of course, we're going to open up the phone lines for any questions you may have in regards to the materials that have been presented. And the Interest Group does not provide investment advice or endorse any products. We are a custodian of self-directed retirement plans, such as your traditional IRAs, your Roth IRAs, individual 401k plans, as well as your employer-sponsored plans, again, as your individual 401k plans, as well as your SEPs and your simple IRA plans for small businesses. We do not provide any sort of investment products. What we provide is record-keeping or custodial services for those individuals who would want to avail of alternative types of investments in their retirement plan. In other words, the investments that are normally not taken at a broker-dealer or some of the banks. The Interest Group specializes in those particular types of investments to be held under a retirement plan. We'll also talk about the different types of investments that you cannot hold in a retirement plan as we go through this particular seminar. All the information and materials that we're going to be providing are purely for educational purposes. This is not intended to offer any sort of investment advice or legal advice. All parties are encouraged to consult with their attorneys, accountants, and financial advisors before entering into any type of investment. In other words, consult with your advisors to make sure that the investment that you're thinking about is suitable for you or makes sense for you before you do any sort of changes to your current existing financial status as far as investing for retirement. Well, again, the agenda for today is we're going to talk a little bit about Entrust for those of you who have never heard of us before or may have never been in contact with us before. We're also going to talk about employer plan to IRA rollovers, as well as we're going to touch on a little bit about funding your IRA via what we call a transfer specific to moving assets between like types of retirement plans. In other words, if you have a traditional IRA at another institution, you could move that to an Interest traditional IRA. If you have a Roth IRA at another financial institution, you can move that via transfer to a Roth at the Interest Group. But the focus of this particular course mainly deals with your old 401k plans, again, 403bs, as well as governmental 457b plans that are allowed to move to IRAs, and in this case, avail of alternative investments through the Interest Group. We'll talk about the benefits of alternative investments in your retirement portfolio, which is something that you could discuss with your investment advisor, your legal advisor, as well as your tax advisor to determine whether or not it's something that would be feasible for you to explore. We're going to talk about what a self-directed IRA is, which I briefly kind of gave you a high-level overview. What are the different types of investment options that are currently popular or used by self-directed IRA investors? We're going to talk about what types of investments are restricted from being held under a self-directed IRA. And last but not least, how do you get started? If you want to open up an account at the Interest Group, we'll walk you through a little bit of a step-by-step process on how easy it is to establish an account with us, as well as how to instruct us in directing us to invest your assets into the alternative investment of choice for you. And last but not least, we're going to open up the phone lines for any questions you may have in regards to the material presented. A little bit about the Interest Group. The Interest Group, again, is an administrator or a provider of self-directed IRA, as well as other types of retirement plan administration. In other words, we provide the plan that allows for you to invest in alternative investments. Again, we do not offer the alternative investments, but we allow for individuals who would choose to invest in alternative investments to come to us so that you can avail of those types of investments in a retirement plan. What does that mean? Some broker-dealers who offer stocks, bonds, mutual funds may not allow for you to hold anything else beyond what they actually offer at that financial institution. It just so happens that we've specialized in holding alternative types of investments because we do have the infrastructure as well as a staff that's knowledgeable in regards to handling your transactions in the self-directed IRA world. We are one of the leaders in the industry, not only for administration but also for education. We do have what we call an IRA Academy, which is approved by the Institute of Certified Bankers through the American Banking Association, that educates not only our staff but also the staff of other competitors in regards to teaching them about the ins and outs of the IRA's rules and regulations, as well as to acquire the designation called a Certified IRA Services Professional through the Institute of Certified Bankers. We have been around for 35 years and process about 12 to 16,000 client transactions every month. And currently, we hold about $2.2 billion of investor assets. So we've been around for a while, and this is basically our niche, and this is what we do well. So we work with other financial institutions in regards to allowing investors to diversify their portfolio, which is one of the things we're going to talk about today. Our staff is knowledgeable again. Most of our staff, if not all, who are eligible to sit for the Certified IRA Services Professional designation through the Institute of Certified Bankers, have their designation or have are going to be taking the exam to acquire their Certified IRA Services Professional designation, which is an industry standard when it comes to vetting out individuals dealing with their knowledge on the IRA space. We have nationwide offices. Some of them are brick and mortar. Some of them are representatives that you can contact certain regions of the United States in regards to questions in regards to self-direction, as well as if you would like to establish an account, we have business development representatives in certain locations, regions of the United States to be able to ask those questions as well as set up accounts. We do have these programs are available for CE credits for some other designations, such as the Certified Financial Planner Board. We are an approved continuing education provider for the Internal Revenue Service, for NASBA, as well as other types of designations as well. So for those individuals who are not only candidates to be investors in self-direction with the Entrust Group, and if you're also a practitioner, some of our affiliates, or not affiliates, but some of our relationships with these other types of designations, you may use some of these courses that we provide as continuing education credits for those particular types of designations. Again, we have national and local in-person events and webinars, since we do have regional reps all over the country. If you have a group of 25 or more, please contact us, and we'd be more than happy to have one of our representatives get in front of your group to speak about self-direction and be available to answer any questions your investors may have. Now let's get into the material. Now, before we talk about 401k plans, 403b plans, as well as governmental 457b plans moving to IRAs, we need to understand that in order for you to take money out of these employer-sponsored plans, you must have a distributable event. The industry calls it a trigger. In other words, if you participate in a 401k plan, you can't just take your money out at any time. You have to reach a trigger in regards to moving that to another type of retirement plan or an IRA for the matter. The Unemployment Compensation Amendment of 1992 is the law that allowed for qualified retirement plans as well as 403b plans to be moved into a traditional IRA at that point, because there were no Roth IRAs. With the passage of EGRA, the Economic Growth Tax Relief Reconciliation Act, if you worked for the government and you had a governmental 457b plan, those can now also move to IRAs. Since it looked and feel like a 401k plan, Congress decided, why don't we just treat this like a 401k plan and allow those individuals who have reached a trigger from these types of plans to be able to move it into another tax-deferred account to preserve the tax benefits or the tax preferential tax status of these dollars and continue on tax deferment for the rest of this person's life, just about. Again, you have to have a trigger. Let's briefly take a look at what those triggers are from these employer-sponsored plans to determine whether or not you may have reached one of these triggers which would allow for you to move your old previous employer-sponsored plan to an IRA. In a 401k plan, if you retire, whether it be voluntary or involuntary, unfortunately in some cases in the country today, some people are forced to retire involuntarily, in other words, getting laid off or a company may be closing down. Death would also be another way to move assets from a 401k plan into an IRA. And in this case, it wouldn't be the dead person, but it would be the beneficiary of such a deceased individual. Reaching a normal retirement age, the plan will define what the normal retirement age is, whether or not you can take your assets out of your 401k plan and move it to another type of retirement plan. Disability would be another one of those life-triggering events that could allow for you to take your money out of a 401k plan and move it to an IRA. Disability is a strict definition under 72M of the code. Don't mean to get technical on you, but there is a definition under the code that allows for an individual to to be considered disabled. Most plans have their own definition as well, but the IRS also has its own definition of disability. In other words, you can no longer work because you're disabled. Or if you do go to work, that your ailment or disability can cause the potential of dying. Typically, a physician statement would be the one that would be looked at, or an IRS or Social Security determination that you are permanently disabled. And in that regard, you can take your money out of an employer-sponsored plan and actually move that to an IRA. The most common these days is severance of employment, similar to retirement. A severance of employment, in other words, you have quit, or whether it be voluntary, involuntary again. Planned termination, of course, is one of those triggers. In other words, some people who work for companies, the companies are closing down. If the company closes down, well, then your assets in that retirement plan can be moved to another tax-deferred account to avoid taxation, as well as maintain the preferential tax treatment of the dollars that you've set aside for retirement. And last but not least, quadros, qualified domestic relations order. In other words, in layman's terms, a divorce. If you are an alternate payee, in other words, you're an ex-spouse of an individual, and a portion of the 401k plan in that particular individual's account is awarded to you, the alternate payee. Some plans, and not most plans, allow for the alternate payee or the ex-spouse to be able to move whatever's been awarded to them to an IRA, and in this case, you have an option of moving into a self-directed account. Again, I'm not advocating self-direction, but it's just this seminar is focusing on expanding your horizons in regards to what's available for you. There are the opportunities that are available. Discuss it with your tax advisor, your legal advisor, as well as your investment advisor, and whether or not it'd be something that would be feasible for your portfolio. For 403B plans, in other words, if you ever work for a school district or nonprofit organizations like hospitals, most of those types of entities have 403Bs. Here are the common triggers: age 59 and a half, death, disability, and last but not least, again, severance of employment. If you're not happy with the investments in your 403B plan or 403B7 plan, which is invested in mutual funds, you have an opportunity to move those assets to an IRA if you have one of these triggers. Lastly, governmental 457B plans. The word governmental is very important because there are other entities that are called nonprofit entities that can establish a regular 457B plan. That is very different, or the treatment of that is very different than your governmental 457B plan. EDTRA, which was passed in 2001 under President George Bush, effective 2002, specifically identifies only governmental 457B plans to have the eligibility to roll over to an IRA. Now, why are we talking about all this? Because in order for us to be able to move assets, again, from an employer-sponsored plan, which is one of these three, we have to have a trigger. We have to understand that there's a trigger. I've had clients talk to me, I'd like to move my 401k plan. I'm not happy with the investments that I have in a 401k plan to an IRA. So I said, okay, let's get the paperwork started. But to come to find out, they have not reached one of these triggers. In other words, the plan administrator of that plan will not allow for you to move your assets from one of these plans to an IRA unless you have a trigger. Here are the triggers for governmental 457B plans: death, severance of employment, age 70 and a half, or retire. Oh, and last but not least, an unforeseeable emergency. It would be something to discuss with the plan administrator of that plan to see if you've hit one of those triggers and to determine your eligibility to move your assets to an IRA, in this case, a self-directed IRA. What you can do with an old employer-sponsored plan. Here are your options again. You can keep the money in your old original 401k plan, 403B, or governmental 457B plan if you're happy with the investments that are in there. In some cases, individuals may also want to retain their assets in a 401k plan if they have assets that are exceeding $5,000. Now, why am I talking about the $5,000? The reason for that is some plans have what we call a cash-out provision. If you've terminated services and your assets are below a certain threshold, and in this case $5,000, and in some plans they put the threshold at $1,000, they can kick you out of the plan if they choose to. In other words, it's called a forced cash-out. The reason for that is your employer, your ex-employer, is still paying fees on your behalf, and in order for them to keep the fees low on the plan, these terminated participants that have balances that are less than that threshold may be forced to take their assets and run. Where can you put those assets? Of course, you can put those assets into an IRA. But if you have assets in a 401k plan that exceeds $5,000, they cannot force you out of the plan. So one of the things you might want to consider is, have you bounced back from any losses you may have had in previous years in the mutual funds that you're typically, invested in a 401k plan? If you have not bounced back, that might be something you might want to consider, whether or not you want to move those assets right away. You might want to wait till those assets do come back, and that's why it's good to go in conjunction with your investment advisor or legal advisor or public or tax accountant to determine whether or not it's a good time to move. But if you are ready to move, you can move that into an IRA, or you can keep your money in the original 401k plan. Moving assets from a 401k plan, 457B plan, or 403B plan, or governmental 457B plan or 403B plan must be conducted in what we call a direct rollover. The term direct rollover means it's reportable. It's reportable to the IRS. There are particular codes under what we call an IRS Form 1099-R, which will trigger the IRS to be notified that those assets are moving on and moving to another type of retirement plan. And one of the places you can move that to is into another employer's 401k plan. In other words, you may have quit from one employer but now work for another, and you like the investments in another 401k plan. You can do that via a direct rollover. Another way to direct rollover is to directly roll that over into an IRA. In this case, you may have a little bit more flexibility. Why is that? Because, even if you move assets to a self-directed IRA at the Entrust Group, you still have an opportunity to transfer that back out of the Entrust Group and move it to another IRA and another custodian who basically makes available for you other types of investments. In other words, you have an opportunity to expand the investment offering that's made available to you beyond what the 401k plan offers. And last but not least, you can always take the money out of your old 401k plan and take it as a distribution. Now, I warn you right now that if you are taking a distribution out of a 401k plan, not only could you be subject to taxation, which, by the way, if you are going to take a distribution out of a 401k plan, the law says that automatically 20% of the distributions that are eligible for rollover must be withheld. In other words, if you have $100,000 in a 401k plan and you want to take a distribution and those assets are eligible for rollover, your check will only be $80,000 because 20% must go to Uncle Sam as a prepayment or setting aside dollars for the taxation of that particular distribution. Now, you can roll that back in within 60 days, but the question is, where are you going to get the 20%? In order for you to be able to avoid being taxed on the $400,000, you must roll back in $100,000 in my example. You take $100,000 out, your check is only for $80,000. You want to avoid taxation, you must roll back in $100,000. If that $20,000 has been withheld, in order for you to be able to avoid taxation on that $100,000, you have to make up the 20%. So although it's an option, be aware that you will have that 20% withholding. So what a lot of people do is choose to directly roll it over into a new employer's 401k plan or roll that into an IRA. By rolling it into an IRA, you avoid that 20% mandatory withholding. In the IRA, if you want to take a distribution, the withholding rate for IRAs is only 10%, and you have an opportunity to waive out of it. Again, the withholding rate for in IRAs for distribution is only 10%, and you have an opportunity to waive out of it if you've had enough money set aside for the taxation of that distribution. Again, in a nutshell, what can you do with an old employer-sponsored plans? What can you do with your old employer-sponsored plan? Your 401k plan, your 457B, governmental 457B plan, 403B, or 403B7 with a mutual fund company. Well, you can keep, again, the money in the plan. You know, if it's to your best interest to keep into your plan, that you can do that. You can also directly roll that over into another 401k plan at another employer if you like the investments that they have in there. If you don't, well, then you have an opportunity to directly roll that over into an IRA. And last but not least, you can also take a distribution. Now, one thing I failed to mention is that not only will your distribution be taxable, it could also be subject to an additional early distribution penalty of 10% if you are under the age of 59 and a half. So it's really best to consider all these different things that we're talking about right now with your tax advisor, your legal advisor, as well as your investment advisor before you act upon anything. Now, again, I'm rattling out a lot of information here, but we're going to open up the phone lines later on to answer any questions you may have in regards to the material presented. How to diversify your retirement portfolio. Don't have all your eggs in the same basket. The SEC, says that all over the place. The Securities and Exchange Commission. Don't have your eggs in all your eggs in one basket. Even in a 401k plan, although there is a diversity of investments that you can hold under a 401k plan, most 401k plans are invested in mutual funds. In other words, you're invested in securities. There are other types of investments available to you. Again, we're not forcing you to move into a self-directed account, but we're just trying to let you know that it is an available option. Opening up self-directed IRA account, you can move part of your funds to reach true diversification. In other words, if you don't want all your assets in securities, and you wanted to buy an apartment complex and you had enough money in that IRA to buy an apartment complex as an example, you can do so in a self-directed retirement account. You can even partner with other people to be able to invest in that particular investment. You can also invest in precious metals that are allowed under a self-directed account. Again, there are more investment options. By diversifying your portfolio, you protect against market fluctuations. In other words, if the stock market goes down, at least your investments are still invested in other types of investments that may retain its value in the event of hard times for the stock market. And last but not least, again, you can hold precious metals, which typically in some situations may hold their value, because unlike stocks where if the company folds, your money's gone. In a precious metal, it may devalue, but it'll always continue to have a value because the precious metal is a tangible asset that doesn't go away. As a matter of fact, if you take a look at American Eagle coins, those are which is actually issued by the U.S. Mint, those are available investments under an IRA, and we do have a precious metals division that is knowledgeable about the different types of precious metals that can be held under an IRA. As a matter of fact, if you check the brochure of the U.S. Mint, they do have a brochure in regards to American Eagle coin, silver, and palladium, that this is an allowable investment under an IRA. With the passage, a little bit of history again, with the passage of the Small Business Job Protection Act of 1996, Congress did create a provision that allows for certain precious metals to be held in an IRA. If that's something that you like, that's available under a self-directed account. Again, what is a self-directed IRA? The individual investor is in charge of making all the investment decisions. It's not special to self-directed IRAs because any IRA you have out there, typically most of them are self-directed. because you direct a custodian to invest your assets, whether it be in a CD, money market account, stock, bond, mutual fund. But a self-directed IRA has taken on the industry term for an IRA held at a custodian, and that allows for you to invest in more, a broader array of investments, such as real estate, such as precious metals, again, notes, or if you wanted to invest in a startup company. Some custodians won't tackle that particular investment because they don't have the infrastructure or the people that are knowledgeable enough to be able to assist you in general questions in regards to those types of investments. The interest group specializes in alternative investments. So our staff can be a sounding board for you and your advisors, your CPAs, to discuss certain types of investments. Of course, we cannot offer tax advice, but we can give enough general information to get you started, or maybe even help in the research for your tax advisors in regards to a particular investment. With that said, it offers a greater opportunity for asset diversification beyond traditional stocks, bonds, and mutual funds. All investments are held in an account administered by a custodian or trustee. An IRA must be held in custody, or the assets for an IRA must be held in custody of the custodian or the trustee. It cannot be held by the IRA holder, because the moment it goes to the IRA holder, it'll be what we call a distribution. So in other words, somebody has to hold those assets at a provider which has a custodian or a trustee holding the assets on behalf of the IRA. And, of course, self-directed IRAs are regulated and governed by the rules found within the various sections of the Internal Revenue Code, as well as some state law requirements in regards to the trust company or the organization that's taking custody of the assets held under an IRA. Now, here again are investment options. This is not all-inclusive, but these are the common types of investments individuals invest in under a self-directed account. Single-family homes, multi-unit homes. Of course, preferably if it's income producing, you get a better bang for your buck. You got two levels of investment increases. Not only the equity of the house, as well as you may also, not you, but the IRA may also receive rental incomes. In other words, you got two levels of income. Some individuals who are reaching retirement age, and by the way, out of the 78 million baby boomers born between 1946 and 1964, 10,000 of them are turning age 60 every day. Now, you ask yourself the question, if you're age 60, can you handle another downturn in the market and wait for your assets invested in mutual funds to come back? Some of them are saying, I don't want to go through that again. Are there any other types of investments available to me that I'm familiar with, such as real estate? In other words, real estate doesn't go away. It may fluctuate in value, but if you purchase that under an IRA, it's not going to go away. So even though the equity may be lower than what you originally purchased, you're still collecting income from that particular property, and eventually, historically, real estate values do go back up, similar to the stock market. But unlike the stock market, where your stocks may go away, a piece of real estate does not go away. Commercial property may also be held under an IRA, improved or unimproved land. In some cases, individuals who may want to invest in unimproved land or improved land may have other types of benefits from that land that might benefit them in their retirement account. Limited liability corporations, C Corps, not S Corps, but C Corps. Offshore real estate held under the custody of a custodian within the United States that, of course, there's certain parameters that the custodian is going to require, such as they have to be provided the fair market value of that account, because those have to be reported to the IRS on a yearly basis. Apartment buildings, co-ops, and condominiums, precious metals, notes, almost anything. There are only three different types of investments that cannot be held under an IRA according to the code as well as revenue ruling. According to code, in other words, when I say code, the Internal Revenue Code, collectibles cannot be held under an IRA. Here are some examples: works of art, rugs, antiques, other types of metals beyond the scope of what the Small Business Job Protection Act of 1996 provides. Gems, you cannot have those. Diamonds, rubies, you cannot have those, because most custodians won't know how to value such an item. And and it's very hard to take custody of those assets. Stamps or coin, alcoholic beverages. As you can see, tangible pieces of property or that's movable cannot be held under an IRA. Life insurance contracts cannot also be held under an IRA. Now, there's an exception to that. Annuities can be held under an IRA through an insurance company, but life insurance contracts that we're talking about here are your, excuse me, life insurance contracts that have an endowment provision. In other words, your term life insurance. By paying a small premium, if you die, incidental to benefit, a big portion will be awarded to your beneficiaries. That's a type of life insurance that's prohibited from being held under an IRA. And last but not least, S-corps cannot be held as an investment in an IRA. An IRA cannot be a shareholder of an S-corp because an IRA is a valid trust under state law. There is a revenue ruling that disallows for IRAs to invest in S-corp. But beyond that, you can hold just about anything under your IRA, of course, adhering to the rules governing retirement plans. And that's where we come in, as well as your tax advisor, legal advisor, investment advisor, because there are certain things that need to be placed in consideration, such as your prohibited transaction rules. In other words, you cannot self-benefit from an investment held inside a tax-deferred account while it's sitting in a tax-deferred account, such as if you move your assets to the interest group and you decide to invest in a piece of real estate, common question some people may have is, can I live in that piece of property? And the answer is no, because that would be what we call a prohibited transaction. So in other words, you have to understand those particular rules, and that's where these seminars come in very handy, because we give you general information that can be used to discuss or arm you with questions for your tax advisors, your legal advisors, as well as investment advisors in regards to what you can and cannot do. Use them. If they are your advisors, use them to be able to vet out whether or not a particular arrangement you want to get into is feasible under an IRA, because us as the interest group cannot give you that guidance because we're not legal. We're not a legal firm or a CPA firm or an investment firm. We're a record keeper. But we will try to give you enough information to point you to the right direction to make an informed decision. How do you get started with the interest group? Number one, open an interest account. We have to go through certain verification process through the Patriot Act in order for you to open up an interest account. Fund your account, and in this case, we're talking about a direct rollover from an employer-sponsored plan, such as your 401k plan, 403B, 403B7, or governmental 457B plan, as well as potentially transfer. Again, I mentioned in the beginning of this course that you can transfer other IRAs of the same type from another institution to the interest group, or in some cases, make a contribution. Now, although it goes beyond the scope of this particular seminar, if you are a small business owner, there are ways to contribute large sums of cash within what's allowable under law into an employer-sponsored plan, which the contributions are actually made into an IRA, such as your SEP IRA plans or a simple IRA. And last but not least, once the asset is in your interest accounts, the interest IRA, then you can direct us to purchase the asset. Of course, the asset hopefully must have been vetted out that your transaction will be allowable. In other words, if you cannot invest in your own company if you're an officer, or if you are, in other words, if you own a company 100%, it would be not likely that you can do that because of the prohibited transaction rules, of course, with the guidance of your legal, tax advisor, investment advisor. You cannot live in a property that is owned by your IRA. Those types of things need to be vetted out. You can set up an account as easily in under 10 minutes by going to this website that we have in front of you, www.theinterestgroup.com/open-new-account. I think it's /open new account. To get started, you also have to have the following items in order for us to determine you are who you are: personal information, a digital hard to say that word, a digital copy of your identification. A driver's license would be the most common one, a passport, a credit card information, so that we can also collect fees. We don't do this for free. We do charge a small fee for opening up and actually having us maintain an account with us, as well as record keeping the asset. Now, if you have more questions about how we charge our fees, I will not answer that in this particular seminar. Please give us a call. One of our business development reps would be more than happy to discuss and let you know what our fees are. I believe our fees are very competitive with the market. Now, if you are going to directly roll over or transfer any assets to the Entrust Group, in this case, mainly direct rollover from a 401k plan, use the promo code PROMOTAX17, and the $50 setup fee will be waived if you use that promo code. So remember that if that's something you'd like to do with the Entrust Group, remember, avail of the promo code PROMOTAX17 to waive the $50 setup fee with the Entrust Group. It's a limited offering, only good from January 9, 2017 to April 18th, 2017. Just so happens that's the tax return due date this year because of the Emancipation Day that is celebrated by Washington, D.C. Again, it's limited from January 9, 2017 to April 18th, 2017. In summary, you have a few options to maximize your old employer-sponsored plan funds. If you don't like the investments held at your old employer's 401k plan, 403b, or governmental 457b, you have an option to roll that into a self-directed retirement account. You must have a distributable event to roll over your assets to an IRA. And another good recommendation by the Securities and Exchange Commission is don't put all your eggs in the same basket. Diversify your portfolio. Invest a little bit in everything, just in case. So just in case one falls, you still have the rest. It increases your chances of maintaining assets for retirement. Take control of your retirement savings through a self-directed account. You have other types of investments available to be held in custody for your retirement plan. And again, if it's held under a retirement plan, you avoid taxation. You have the diversity investment options from real estate to precious metals, notes, whatever it may be that you want to invest in, a startup company, whatever you want to invest in under a self-directed account. And last but not least, you can get started in 3 simple steps. Well, I've taken up a lot of time talking about how to roll over assets from an employer-sponsored plan to an IRA. Now it's time to open up the phones for questions. Okay, I am getting quite a few questions already here. And what I'd like to do is try to go through as many as I can if I can answer them. It says in here, if you retire and move your 401k plan into a self-directed IRA with a bank, can you roll that over to your self-directed IRA at the Entrust Group, I'm assuming? The answer is yes, you can. It wouldn't be a rollover. As I mentioned earlier, if you rolled over your 401k plan to an IRA at another institution, you can transfer that IRA of the same type to the same type of IRA at your Entrust Group. So in other words, let's say you retired from ABC Financial Institution and you rolled it over to XYZ Bank, to a traditional IRA. What you could do is set up a traditional IRA at the Entrust Group and then transfer that traditional IRA from that XYZ Bank to a self-directed traditional IRA at the Entrust Group. That happens all the time. Absolutely. You are able to do that at any time. Okay. Here's another question. Does self-directed IRA allow to invest in real estate, i.e. rental property? If it's how profits send back to the IRA and how all processes work in that regard. That's a good question. Yeah, you can invest in investment property that actually has rental income. As a matter of fact, rental income under tax-exempt accounts, which an IRA is one, is not taxable. So in other words, you buy a $250,000 piece of property and it makes, let's say, $20,000 a year in rental income. Number one, to answer your question, the rental income must be paid back to the IRA. Whether it be the renters make their rent checks payable to the IRA or payable to the Entrust Group so that we can deposit that into your account, or in some cases, IRA holders also, let's say, hire a property manager. And the property manager collects all the rent, and then the rent is sent by the property manager directly back to the IRA. So to answer your question, the incomes for investment properties have to go back to the IRA. And, of course, it's not taxable as long as you purchase the property outright. And I hope that answered your question. Yeah, you can have an investment property that has income, but the income has to go back to the IRA, whether it be, again, the renter pays the checks directly back to the IRA, or there's a property manager involved that collects the fees and then sends the assets to the Entrust Group. Okay, now here's another question. How long has Entrust been in business? 35 years. As a custodian, how can you ensure that you will not run away with the money? Because we are governed by state regulators. If the Entrust Group, of course, your assets are being held under a trust company that is regulated by the state. If the Entrust Group does fold and goes into receivership, those assets are awarded to another trust organization, similar to what happens to banks. So we don't just run away with your money. I mean, we've been around for a long time. What government agency is supervising the activities? State governmental agencies, the IRS, the Department of Labor. We do have to cooperate with a lot of state local agencies as well, because sometimes, clients may be involved in other things. Those are the types of entities that regulate the Entrust Group. Banking regulators also come in. We do go through a yearly audit, and as well as all the necessary insurances thereof as an organization. Yeah. Another question. I guess you are not covered by FDIC like banks. No, only cash accounts are covered under FDIC with the Entrust Groups. In other words, if you have a self-directed account with the Entrust Group and you invest in real estate, that is not covered by the FDIC. But if you do have let's say, rental income coming in, and it's under a cash account under your account, that is invested in an FDIC-insured account. So in other words, FDIC covers the cash accounts but not covering the piece of real estate. Similar to your stocks and bonds and mutual funds, those are not covered by FDIC as well. SIPC only covers the cash portions of a brokerage accounts. So next question. Can people that not triggering events such as death, retirement, roll over to a 401k plan? The answer to that question is typically no. Because in order for you to take money out of a plan, you have to have one of those triggers. There are some plans that have what we call an in-service distribution, and I did not talk about this in a seminar for the sake of time. An in-service distribution only allows for you to access vested employer dollars out of your employer-sponsored plan if the plan allows for it. So it may be something you might want to check with your employer if you have not reached one of those triggers to see if your plan has an in-service distribution provision. If the in-service distribution provision is subject to a hardship provision, in other words, the only way you can take your money out is in the event of a hardship, that also cannot be rolled into an IRA. But check with them to see if you can take an in-service distribution and it's not subject to a hardship clause. Then even while you're working, you can at least access some of your assets out of the 401k plan if you really want to invest in through a self-directed IRA. I hope that answered your question. Kind of going really fast again for the question in regards to if you don't have any trigger. Check in regards to an in-service distribution provision. In other words, if you wanted to access your matching contribution, profit sharing contributions out of your employer's 401k plan, they have an in-service distribution, and those dollars are vested. In other words, you've worked long enough for the company that you own that money. You may be able to take just that money out and roll it into a self-directed IRA. I hope that answered your question. Here's another question. What's the name of other firms doing self-directed IRAs like Entrust? And of course, I don't want to advertise other organizations in this particular webinar. It may be something you can give us a call. Or Google it on the website, on your internet, to find out who else is doing self-directed accounts. A lot of bigger banks like JP Chase, I can tell those because those are, they're restrictive. JP Chase, BMO Harris Bank, private bank. A lot of the private banks for the larger banks do handle self-directed accounts, but they have minimum balances that are required, and they do charge a large amount. Most of the time, these private banks charge on a percentage basis based out of your assets. So in other words, if you have self-directed accounts, they may be charging, because they have to charge a flat fee based out of a percentage. they can charge as high as 1% to 2%. In other words, if you have $100,000 in there, and if you want to go to one of these banks and they charge you 1%, that's $1,000 a year. Our fees are a lot smaller than that. So anyway, it's something to do some research on, other types of institutions that actually offer self-direction. But for us, we've been around for 35 years, and as a matter of fact, we do hold a school and we educate other institutions as well in regards to self-direction. All right. I hope that answered your questions. What about LLCs? Yeah, you can invest in an LLC as long as there's no conflict of interest. There are entities out there, organizations that you might like to invest in. Then the IRA will be what we call a member of that LLC. Incomes from that LLC may be taxable to the IRA. In other words, although IRA assets typically do not get taxed, but if you invest in a company, such as an LLC or a partnership, depending upon the type of business that LLC engages in, you may have taxation on the income. There's a publication 598 by the Internal Revenue Service that may be good to read up on, as well as discuss with your tax or legal advisor. But if the LLC is invested in, as an example, real estate, and there's income, rental income, those are not taxable. But if the LLC engages in a trade or a business, like a restaurant or, let's say, a laundromat, type of business that basically is for profit, well, then the income from the LLC, which is passed on by a K-1 to the IRA, which the IRA has to file a tax return called a 990T, must pay taxes on its income that is in excess of $1,000. Again, that's all spelled out under publication 598 of the Internal Revenue Service. The taxation of an IRA is a little bit different than your personal taxation. IRAs, since they are trusts, are taxed as a trust and under trust tax laws, which is a lot higher than personal income taxation. So in other words, when you say, what about LLC, it's kind of a broad question, but I hope I gave you enough information to point you to the right direction. Here's another question. What are the fees and their breakdowns? It'd be something that give us a call. We'd be more than happy to discuss that with you in regards to how we charge fees. We either charge a flat fee or we charge a percentage based out of the assets. If the assets are small enough, you're probably better off with it based on a percentage. But if the assets exceed a certain threshold, then you might be better off with a flat fee. But give us a call. I'll be more than happy to discuss that with you. Here's another question. When you say large amount, what is that amount? I don't quite get what that means. But when you're talking about investing, let's say, in $1 million and you're charging a percentage, you might be better off. I don't know if that's a question. You might be better off using the flat fee for the interest group. So in other words, your fee does not increase as your investment increases. I hope that's what you're asking. Do you offer self-directed Roth accounts? Yes, we do. We also offer self-directed individual 401k accounts, SEP IRA accounts, self-directed simple IRA. So not only do we offer traditional Roth, we also offer SEP IRA, which is nothing more than a traditional IRA receiving a SEP contribution. But of course, SEP contributions are a lot larger. It's 25% of your income from the business, or up to $54,000 for 2017, $53,000 for 2016. So, I mean, those are employer-sponsored plans, as well as simple IRA. So not only do we offer traditional, Roth, SEP, simple, and also individual 401k plans. Instead of IRAs, yes, we do offer, again, here's another question. Do you offer self-directed Roth accounts instead of IRAs? Yes. Individual 401k plans, SEPs, and simples. Can I use IRA as a down payment for a rental property? How does that work with bank? Will they issue the loan with my name? It is not advisable to get a loan from a bank using your IRA as a down payment. The loan typically handled through an IRA is what we call a non-recourse loan, because when you purchase a piece of property held under an IRA, you personally cannot guarantee any portion of your own credit to that IRA. That is what we call a prohibited transaction. So typically what loans that are used to purchase a property when you don't have enough IRA assets to purchase a piece of property is what we call a non-recourse loan. It's a specific loan that if it goes in default, well, the lender can only go after what's in the IRA and not you personally. So in other words, you cannot use your own credit to get a loan to purchase a piece of property held under your IRA. It could be prohibited. So what a lot of the industry uses is what we call a non-recourse loan. Non-recourse loans are provided by either banks, there's some private lenders, and there's a list available in regards to who the non-recourse loan lenders are. Their underwriting guidelines are a little bit different. You must have enough skin in the game. In other words, your down payment must be a lot higher, and that the income that is received from that particular investment must be enough to pay back the loan. So those are the types of provisions that non-recourse loan lenders look at. Can you use income generated by your rental property as a down payment to buy a second property? Yes, absolutely. You can do that. Here's another question. If I set up and manage an LLC that purchases investment property, can my IRA invest in that LLC as a member? There are prohibited transaction rules in regards to an IRA investing in a company that is owned by the IRA holder. That would be something that you might want to check with your legal counsel, as well as the IRS has what we call a frequently asked questions portion dealing with what we call prohibited transactions. That might be something you might want to check out and vet out before you proceed in any kind of transaction like this one. 49, as a matter of fact, you can Google it. Internal Revenue IRC 4975 that deals with who a disqualified person is, and also talks about what you can and cannot do. Right? Is there a limit on how much property you can hold in an account? There is no limit. As long as you have assets to purchase property, yeah, you can buy 10 property. I've seen people hold as much as 40 pieces of property. Great investing, and a lot of them are not saving it up for themselves. They're saving it for who? Somebody else. They're beneficiaries. The beneficiaries, it goes beyond the scope of the seminar, can actually enjoy a lifetime stream of income if you worked hard enough and saved up enough in your retirement account, because the current regulations, as a matter of fact, you'll find that on Article 4 of the IRS document, spells out what the options are of beneficiaries once the IRA holder dies. So in other words, to answer your question, is there a limit on how much property? You can hold as much property as you want, as long as the assets are in your IRA. Now keep in mind, the assets used to purchase a property cannot just be dumped in an IRA. It had to be transferred from an existing retirement plan outside, or funded via contribution. JP, you just gave a great question when you mentioned cash in a self-directed account. So the way self-directed IRA account works is that you will open an account in a bank, or if you have real estate, how do you pay expenses if you do not have a linked bank account? Okay, that's a good question. You do not open up a cash account on another institution. What it is that within your interest account, you have a cash account invested in an FDIC-insured account. So if you have expenses that need to be paid, which, by the way, it's a good thing that you raised that up. If you own pieces of real estate under an IRA, the expenses must also be paid from IRA assets. That's a good question. Some custodians use what we call a payment authorization form. So in other words, every time you have to make a payment, you have to fill out a payment authorization form, send it to the custodian, they charge you a small fee, and then the custodian sends a check to whoever you want to pay to. It just so happens that there's a mechanism that the Entrust Group devised that makes that process a lot easier. It's called a My Direction card. Using your cash account in your IRA and paying a small fee for the My Direction card, which is a couple or $3 every month. I mean, don't quote me on that, but it's very inexpensive because we have to pay the vendor. You can pre-fund that card and use that card to pay expenses that are incurred by that investment held under your IRA. Now keep in mind, any charges on that card, we will issue a 1099-R unless you manage the expenses that are being paid out of your account. you can do that through the website. And, for example, if there's a can of paint that was purchased by that card because your painter needed a can of paint to take care of it, or property taxes were paid from that card, well, then you have to identify those expenses that are IRA-related expenses. If they're not identified as IRA-related expenses, we, the interest group, as your custodian, have to issue what we call a 1099-R to the Internal Revenue Service. So to answer your question, the cash account, is going to be held under your interest account, and that account can be used to fund a prepaid card to pay for expenses. If you choose not to do that, that's fine too. Then we just go through the payment authorization process, and you give us a form, you tell us who you want us to pay, and then we'll be paid from there. So, but to answer your question, yeah, there are mechanisms involved in how to pay expenses directly from your IRA to those expenses without having to go through that whole process. I hope I answered your account. I hope I answered your question. Here's another question. Does a self-directed solo 401k also pay UBTI for LLC earnings? Okay. Self-directed solo 401k plans are subject to UBTI. When you say solo 401k plan, that's the same as an individual 401k plan. Individual 401k, the term individual 401k plan was coined by a company I used to work for. I was one of the team members that created that name. A solo 401k plan created by Pioneer Funds it's the same as an individual 401k plan. I just want to get that straight. Individual 401k plans under 401A of the Internal Revenue Code has the same rules. You have to pay UBTI, unrelated business income tax. It just so happens that if you leverage your plan to purchase a particular piece of investment, in other words, your plan borrowed to purchase a piece of real estate. In other words, you had $100,000 in a solo 401k plan, individual 401k plan, and you wanted to buy a $200,000 piece of property. So in other words, your plan borrowed to purchase a $200,000 piece of property using a non-recourse loan. Whereas in the IRA, based on a percentage of what was borrowed and what was in the retirement plan, in the IRA world, if there's any income, the percentage that was borrowed will be applied to any income to determine what's taxable. So in other words, in my example, we got 50-50, $200,000 piece of property, $100,000 owned by the retirement plan, $100,000 borrowed, 50-50 ratio. I'm just going to use that for simplistic terms. If income of $20,000 comes in from that piece of property, that tells us that $10,000 of that, or 50%, is attributable to an amount that was already in the plan, and the other $10,000 was attributable to an amount of income that was based out of the percentage that was borrowed. The percentage of income attributable to the amount that was borrowed is typically taxable if it's under an IRA. It's called unrelated debt-financed income. I'm getting complicated on you, but you asked the question, so I'm going to answer you. Unrelated debt-financed income. It's also outlined under Publication 598. In the IRA world, it's taxable. In the solo 401k plan, in the individual 401k plan, UDFI is not taxable. It just so happens that they carved that out under the law. Under Section 514C of the Internal Revenue Code, it's carved out. So if you have unrelated debt-financed income in a 401k plan, that is not taxable. But UBTI still applies. So if your solo 401k plan invests in a business and that trade or business has income, that is taxable to the solo 401k plan. So in other words, I wanted to delineate the different types of incomes and what is and what isn't taxable. UBTI applies to individual 401k plans and solo 401k plans, but UDFI does not apply to individual 401k plans or solo 401k plans. I hope that answers your questions. The next question is, are informational webinars such as this available on an ongoing basis to Entrust customers? And the great news is, the answer is yes, it is. It is. You might get a long, drawn-out answer from me from these educational programs, but I'd rather give you more information that you care to hear about than say that JP never talked about this. I'm trying to equip you with as much information to get you started so that you know how to ask the questions to your tax advisors, legal advisors, as well as investment advisors. Here's a question. What happens when a property bought by a self-directed IRA was foreclosed? Would that be a write-off? Now, keep in mind, if it's held by the IRA and it's not held by the investor, it is not, you cannot use that as a tax deduction. It's typically, there's a special rule in the Roth IRA, which I'm not going to go through right now, but if a home is purchased by an IRA, and that investment gets foreclosed on, I'm assuming, of course, you have a loan on it, then that's not right. You can't write that off because all gains and losses are all suppressed under an IRA. Okay, here's another question. What is the maximum that you can invest each year? Well, join our contribution course. It'll tell you what you can contribute into an IRA. The maximum contribution for traditional IRAs this year and Roth IRAs, because that one combined limit is for both traditional and Roth, is $5,500 for someone who's under the age of 50, with an additional $1,000 if you're 50 or over. If you also have a business and you can contribute because you have enough profits in the business, you can contribute the lesser of 25% of your income, of course, with certain adjustments depending upon what your tax filing status is, whether you're self-employed or a corporation, partnership, etc. That's where your tax advisor comes in. It's the lesser of 25% of your compensation, or a maximum of $53,000 for 2016 and $54,000 for 2017. Those are what we call your SEP plans. And there is a publication 560, that would be a good reference for you, a resource for you, to find out about the different employer-sponsored plans if you want to make that higher contribution. Now, the maximum that you can contribute or move into a self-directed IRA is limitless. If you already have existing accounts, in other words, traditional IRAs in another financial institution, or Roths, or an old 401k plan, which is the focus of this course, that can be directly rolled over into an IRA at the Entrust Group or transferred into a same type of IRA at the Entrust Group. Well, that concludes our seminar for today. Again, my name is John Paul Ruiz, Director of Professional Development here at the Entrust Group. I hope that you found this particular seminar to be informational as well as helpful for your decision-making process in regards to considering what to do with that old 401k plan at your old employer. I thank you for attending today's seminar and look forward to having you on another seminar brought to you by the Entrust Group. Have a great day.